Hi, this is Justin Lawrence from Lawrence & Associates, and today we're going to talk about the effect that filing bankruptcy by one spouse has on the spouse who doesn't file bankruptcy. We're often asked by one spouse whether or not filing a bankruptcy on their own will affect the other spouse for a couple of reasons. Sometimes it's because the spouse who needs to file bankruptcy has taken out debts before the marriage that have now gotten out of control. Other times it's because the spouse who needs to file bankruptcy took out debts that the other spouse didn't co-sign on, either with or without the other spouse's knowledge. The first answer to the question is simple. The spouse who is filing bankruptcy has their Social Security number on the bankruptcy filing, and a spouse who does not file bankruptcy does not have their Social Security number on the filing. Therefore, the credit rating of the spouse who does not file bankruptcy will not be impacted by the bankruptcy of the spouse who filed. The spouse who does not file bankruptcy does have to supply their income and revenue information because the budget that's submitted by the filing spouse has to include all household revenue, which includes the revenue of the spouse who's not filing. That can affect whether or not the filing spouse files a Chapter 7 or a Chapter 13 bankruptcy, so the records of the spouse who's not filing don't get left entirely out of the bankruptcy. It's important to understand whether or not your debts are joint debts or just a single spouse's debts before you file. If one spouse files on a debt that both spouses have co-signed on, the spouse who filed will get out of the obligation of having to pay that debt, but the spouse who did not file would still have that obligation, and the credit card company or other lender could choose to sue the spouse who did not file bankruptcy. Another thing you have to worry about is assets. Assets that are owned in both spouses' names are going to be at least 50% property of the bankruptcy. That means that a trustee could potentially seize an asset even if it's owned partly by someone who didn't file the bankruptcy. Also, assets that are not owned by the spouse who filed bankruptcy are not considered part of the bankruptcy estate and therefore can't be seized. Again though, if that is an asset such as a car that has a loan against it and both spouses signed on the car loan, the lender for the car could still seize the car or repossess the car if the non-filing spouse doesn't continue to make payments on it. If you have any other questions about the effect of filing bankruptcy on a non-filing spouse, you can visit our website at www.lawrencelaws.com or call one of our attorneys for a free consultation.